I'm criminal defense attorney Joseph Abrams. Today's video is the first in a three-part series in which I explain the federal criminal process in easy-to-understand terms. Today, in Part 1, I discuss the investigation and pretrial phases. In Part 2, I will discuss the trial phase. And finally, in Part 3, I will discuss the sentencing phase. So, let's start by talking about the investigation. When a crime is first brought to the attention of federal authorities, a federal law enforcement agency will open an investigation to determine if a federal crime was committed. If the agency concludes that a federal crime was committed and identifies a suspect, federal law enforcement officers may make an arrest or seek an arrest warrant, or may continue the investigation without an arrest to obtain additional evidence proving the suspect's guilt. In most cases, the investigation will lead to the government seeking to obtain an indictment from a federal grand jury. If the grand jury concludes that there is probable cause that the suspect committed a federal crime, the grand jury will issue an indictment charging the defendant with those crimes. Now, let's move to the pretrial phase. The first court hearing in a federal criminal case is the initial appearance, which must occur within 72 hours of the defendant's arrest. At the hearing, the court will inform the defendant of the charges and advise them of their rights. In some cases, the defendant may then also be released. But in other cases, the government may seek to have the defendant detained pending trial because they are viewed as a flight risk or a danger to the community. The next hearing in a federal criminal case is the arraignment, during which the defendant is formally charged and provided with a copy of the charging document. At the hearing, the defendant will enter a plea, which in most cases is not guilty. However, it's not uncommon for the defendant to enter a guilty plea at this stage if the parties have agreed on a plea bargain. If the defendant pleads not guilty, the case proceeds to what is known as discovery and motion practice. Discovery is the process by which the defendant may demand to see the government's evidence against them. Motion practice is the process whereby the parties file papers with the court asking the court to do something in the case. Motions can cover a variety of areas, such as a motion to dismiss charges, to suppress evidence, or to allow specific evidence at trial. During discovery and motion practice, the parties will often negotiate a plea agreement as they learn more about the evidence and the strength of the other party's case. If the parties are unable to reach a plea agreement, then the case proceeds to trial. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope this has been helpful, and we'll see you next time in part 2 of the series when we discuss the trial phase of the federal criminal process.